Good morning, everybody. Good morning, good morning. Lecture number 2. And thank you for all the doodle registrations. We will discuss that in the upcoming workshop. But maybe it's helpful to confirm that, let's say, the majority of all students is now in 18 and is connected to a company. I did receive no emails yet on, let's say, issues on that level, as in I cannot find a proper company or a teammate. So don't hesitate if that is needed, almost in time. And I hope today to say many meaningful things you can use in your paper, so that in these days, where on Thursday coming we do not have a workshop, you already can start working on that midterm exam, and with self-study can accommodate and accustom yourself with the learning outcomes of this course. Well, now that we are all seated and awake, let's discuss today the first 3 items of the universal aspects or aspects of corporate law, as discussed in the mandatory literature, with a preliminary view on legal rules in itself. Why? Because the idea is that in your paper you reflect on the chosen company through these principles. So it is a tool to describe a company. Why? Because you can do a company analysis in many different ways. And you did company analysis in other courses already through the eyes and in the angles of such a course, like liquidity, like accounting, like market share, like marketing, or other angles connected to courses you have. So what I expect in this course and in this paper is that you put on your legal scholar modus in writing on the company. So don't give me, or the class, a economic analysis of the company. Try to make it as heuristic, legal as possible, to make a distinction between. So that is a task. Secondly, you can discuss a case, a issue as described in newspapers, as you will encounter in your professional life through or via different avenues. And again, also in discussing a case, I invite you in this course to use the vocabulary of the legal scholarly analysis of this book. So one of the assessment tools, one of the ways I assess you, I grade you, whether you are successful in mobilizing that vocabulary. And then solving a case is a sort of lawyer's language for generating a question, whether there's liability or not, whether there's a legal person or not, whether there is a proper governance structure or not. So discussing a case is sort of free for all debate on, well, these are interesting aspects. And solving a case is first identifying the critical question. For instance, is there liability? Yes or no? So play with these 2 things. In the paper, it's more discussing a case. And then in later workshops, we will move on to solving a case. There is a slight difference between that, and the 2 of these items we will both test in paper and in the exam. Well, what are the key aspects? Legal personality, investor ownership, delegated management, and then liability, and fifth, the transferability of shares. And I will continue to use those icons as a sort of mapping device in the vocabulary around the corp. And then we have 5 for additional domains or principles or aspects. One is the property perspective, so assets and finance. Then the second item is the ingredients of operating, as in labor and also capital again. Then we have the interaction, so production and sales of products. And last but not least, the regulatory landscape around a enterprise. These are, if you wish, a subdivision of the life of an entrepreneur or a company or your professional life. And if you want to force that in 4 sort of categories, then these are the 4. You can make 10 categories, you can 20 categories. And so what I try to do is bundle the discussion in ultimately 5 + 4 is 9 type of categories. And that means that if you dwell on one and you spend a couple of pages on that, maybe you consider to move on to another category to also include in your analysis where possible. So if I try to bring the corporate world, the corporate law world to you in 9 categories, that is nice and helpful for satisfactory grades if you try to hit all of them one way or the other. In the paper, we are not yet at the end of all 9. So then maybe you stay with the first 5. But I invite you to see whether other topics are already doable. Okay. That is recap, repetition of last week. Welcome those who were not there. Let's test the attendance via a lovely attendance list. There's a second column with a date called 21st of November, and try to make a little ink mark of yourself as proof of presence. Alright, then we will discuss how legal rules will affect these 9 topics, and I would like you to reflect on the concept of a legal rule. What is a legal rule? A legal rule is a tool to answer a concrete question. And what are concrete questions? Concrete questions are who, where, and when, and how much, and until when, and what if, and how to, and which organ, and what amount. That is what we call concrete questions. And then, based on logic, law is logic, partly, the corresponding answer fits neatly to that question. As in, who, that is Mr. X or Mr. Y or Mr. Z, and those are the options. So how I invite you on this slide to look at legal rules is, what are the options? If you were a designer of legal rules, and you will be designer of legal rules, one way or the other, we will discuss that maybe one day, please consider what are the options. It's not rocket science. So take a very down-to-earth view. Secondly, where are legal rules, for the time being, in territories? Let's discuss it in a minute. Then we have types of rules, and that is a limited list. So we have acts of parliament or statutes, we have regulations, could be those acts of parliament or executive branch rulings or the like. And we have court cases as source of legal rules. And then legal rules as in answers to who, where, when, how much, until when, what if, how to, which organ, what amount, etc. So no spooky view on legal rules, but a very down-to-earth concept. And then we have drivers. Drivers that shape the actual rule. And that is something very important to consider. We have drivers from the human rights perspective, and mind you, the right to property is one of those fundamental human rights in most jurisdictions. So the assessment of the legal rule is successful comes from the drivers, including human rights. Secondly, the society, the sort of incomprehensible movements within a society that all of a sudden tax haven arrangements in tax law in the Netherlands is an issue. So driver as in a force you cannot sort of easily beat or guide, but which is there. And then last but not least, I call it capitalism, the mechanism of return on investment. So the mechanism that if you have assets, then you would like to make good use of them, and corporate law rules are driven by that desire to deal with your assets in an appropriate way. Another picture I developed on the drivers of the actual rules is a little bit the same in a hierarchy. So from a legal perspective, we put those drivers in a certain hierarchy. And then, legally speaking, the human rights, fundamental rights driver is the highest. Both ways. Two examples. Child labor, we will discuss in week 7. Child labor is bad. That is sort of the simplistic sort of human rights perspective on one of the means of running a business. But equally important is the human rights of owning property, owning assets. So expropriation is bad. So wherever rules in corporate law discourage owners of assets, of financial capital, to make good use of them, that is also bad. So here we have conflicting fundamental rules, and that makes corporate law very interesting. Otherwise it was very easy, then it was just a matter of avoid child labor and then you are okay. It is not that simple. That's beautiful. Legislation and regulation in the sense of that drives corporations, entrepreneurs to design themselves and form themselves in a specific way. And then, last but not least, litigation, a risk-avoiding attitude is key in corporate law. You do not want to end up in court debating legal personality, investor ownership, all kinds of issues, because then it's too late. That is sort of, in economic terms, far too high transaction costs in terms of achieving your goals. So use that type of language in your own analysis, so that you have this sort of helicopter view. Well, let's discuss almost 80% of world population by selecting jurisdictions in a sort of top 10 fashion. China, I put the link on Chinese corporate law on Blackboard. India, also on Blackboard. Then the European Union with 500 citizens, the third territory, if you take that as one jurisdiction. Fourth, a misuse of history, putting Pakistan and Bangladesh in one box, but together they share a legal system from the British system, and they are worthwhile not forgetting. Together 355 million, and those are figures of last year, so I believe it's already more. And so they are together the fourth territory. They used to be one country, they are now two countries. USA, Indonesia, Brazil, Nigeria, Russia, Japan. Those are the sort of top 10 countries that make sense to discuss. And then within the European Union, we make a similar sort of top 10. And what we mainly focus on is Germany and the Netherlands within the scope of this course, because there is not more time. Okay, then key is the perspective of Krakman and his team, and that is that he divides corporate law in sort of two realms. The first realm is the structures of the corporate forms, so I call it business view. What types are available and how are they designed? And business law approach, remember the first lecture we said, well, that is the quick and dirty explanation. Where can I get my limited liability corporation and what form should I sign? That is sort of one function of corporate law. And then the second function identified in this approach is the function to control the conflicts. And then conflicts between who? The conflicts between principals and agents in a sort of law and economics perspectives of reducing transaction costs and to favor and stimulate the aggregate welfare, social welfare approach. Then they, in the chapters of these 3 weeks, there are 3 contracts central. This contract or the conflict, potential conflict between the owner and the manager, owner, investor, and delegated management. Secondly, majority shareholders, minority shareholders, and thirdly, the enterprise itself, so the legal person, and its third parties or outsiders, as in very close outsiders called employee, and a little bit further outsiders called customers, suppliers, and other contract parties. And so that is the question. Please be very specific on who's then the principal and who's the agent, because there's a sort of role shift. An alternative? No. And then how does, according to this analysis, the law solve these conflicts? With 6 tools. 6 perspectives on how a specific legal rule, as discussed earlier, should function. So this is a test whether it is an appropriate rule, as in the protection of vulnerable parties, vulnerable in a principal-agent conflict. For instance, a minority shareholder in a conflict with a majority shareholder, then the minority shareholder is the vulnerable party, and so forth, and so forth. Then the strategy could be rules, we will discuss that in a second, standards, as in non-binding standards, as in governance codes and the like, and in terms for entry or exit. Terms as in, if you want to enter a shareholder position, then there are rules accompanying that purchase. For instance, disclosure rules on the details of the shares you're about to purchase. Think of the prospectus obligations in a initial public offering or other public offerings. You're familiar with that. Then the second identified strategy that is helpful within the realm of corporate law is the reward. Reward as in, if we pay the agent enough, then he or she will take care of my interest as a principal. Think of bonus discussion. So these salaries or rewards for an agent are not just for fun or just because there's enough cash in the company. No, that is a tool to solve a potential conflict between the agent and the principal. That means that blocking bonuses, as the Netherlands does, then you interfere with a optional strategy to solve a real conflict. And that means that if you propose rules in a jurisdiction that limits salaries and bonuses in a territory, like we do in the Netherlands, then you should come up with other solutions to mitigate the loss of that strategy. Thirdly, the removal law, the power to remove a strategy, and that is a very central strategy to solve principal agent conflicts. And in down to earth, that means the power of shareholders to appoint and dismiss a manager, a board member. And that's a very powerful mechanism in this principal agent conflict. Fourthly, the power to ratify that certain decisions, resolutions of an agent, for instance in the board, have to be ratified, approved by the principal. And we will need several legal rules in specific jurisdictions that facilitate this strategy. That in your articles of incorporation you can codify the right of the general meetings of shareholders to approve certain decisions of the board. For instance, in mergers or acquisitions of large subsidiaries or financing deals, etc. And then we know in the realm of this course where that comes from. And then disclosure and enforcement we will discuss later on. An alternative view on those strategies is developed by Mr. Ogus, and these are the design options of law and regulation. So this is an alternative view, 5 C's, and then the first C of command is the strategy of a legislator or rule maker to make a very explicit rule, please, or like contractual liability, the legal rule that if you sign a contract, you're obliged to honor the contract, and if not, there are punishments as in damages and so forth. So this is the classic legal rule. This is the 95% so far that lawyers think how they can effectively regulate a complex matter as, for instance, corporate law. And we saw already that there are 6 other strategies, and let's see how lawyers respond to that. The second one in this list is competition. That you create incentives, for instance with emission rights or with regular competition law, that there are, or with tax incentives, that you favor a certain type of products and services, for instance with electric cars, and that you are not creating a command rule as in gasoline engines are forbidden. No, you favor, with fiscal or other legal means, another type of activity, both in terms of products and services, but also in legal forms. You can favor a limited liability company as opposed to corporations or to cooperation, sorry for the mismatch. Competition as a strategy to achieve a certain rule or a certain outcome. Thirdly, collaboration. The buzzword as in network society. That it is not a matter of top-down, government, entrepreneurs, but that you cooperate around projects like renewable energy, and that as a state you are not making command rule, we forbid gas mining and everything should be electrical. No, you join up in a sort of team. The legal tool is contracts, and together with entrepreneurs, consumers and the state you create, for instance, windmill parks in the North Sea. Collaboration. Fourthly, communication. To influence a certain outcome, you can communicate, for instance with scholarly reports, that a fair balance between men and women in boards is a good thing to go for. And other examples are advertisements on television. For the Dutch listeners, Postbus 51, this governmental information on the healthy consequences of eating vegetables, or all kinds of other communications that already could influence, or isolating your homes, that could influence behavior. And last but not least, code. The best example is the speed bump. You create something in the architecture where, as a consequence, the users of the roads reduce their speed. So you can put signs on the street, please take care of our children. You can put fines on speeding in the commands, but you could also create speed bumps, and then, funny enough, people love their car, they reduce their speed, otherwise you wreck your car. And the ultimate dream of lawmakers is that you think of speed bumps, for instance in corporate law, where it is impossible to achieve the wrong outcome. So that is something to take into consideration. Let's move to the first topic out of the 5 and look at the legal person. There are various names, and to name a few, we have the name separate legal personality, which is used in Germany and some states of the United States of America. And what I like of this name is the word separate, because separate from the owner. Other names are legal personhood, indicating the feature that it is as if you are a person. To avoid the debate that, as such, legal person could also be also mean a human being, because human beings, when they are registered in the civil registry and having a passport, then they are also sort of legal person in a sense. So all these words in a comparative setting could lead to confusion. And one of the ways to avoid confusion is that you double up words. That you say legal person as in separate legal personhood, and that you double up each contagious phrase. Then we have the nationality discussion. Let's discuss that immediately, because that is very interesting, and from a legal perspective, a sort of hot debate. Because where it comes to the nationality between emphasis of a legal person, then there are 2 options. One option is the incorporation doctrine, and the incorporation doctrine is a thing within the legal brain that says that once you are incorporated in any jurisdiction on the globe, it is only a matter of recognition in a other jurisdiction as if you are a human being traveling with a passport. This means, the incorporation doctrine, that a jurisdiction as the Dutch jurisdiction with a company register is able and legally allowed to register all the companies on the globe as Dutch corporate citizen. So all the Dutch flavors, limited liability, BV, NV, they're in the register, and all the other corporations, and that is called a branch. So if Siemens is opening a office in the Netherlands, as they did, in The Hague and Utrecht and all over the place, then like with human beings, you need to be registered somewhere, you need to be sort of residence permit, but then the corporate version, and that is then done via a registration in the company register of that German GmbH. That's one thing. The competing doctrine, which could be embraced by a country, is the real seat doctrine, meaning that in real seat jurisdictions you cannot register your own legal form. No, you have to completely re-establish a new legal person, a new separate legal person in that country, like Germany or France or Belgium. This is a way to favor your own legal forms and to hinder and hamper international trade and economic approaches that look at internal markets and a free flow of capital and labor and so forth. Within, or now that the real seat doctrine exists, meaning that France traditionally only recognized their own SAs and SRLs, that caused a lengthy, decade-long debate, for instance, in the realm or in the context of the European Union. So there's a long list of case law and EU regulations that try to solve the real seat doctrine. Because you can imagine that if you have to re-establish Philips again in France and in Belgium and in Germany, that is a headache compared to just registering your NV as a branch in those countries. The bottom line is that within the European Union, through the mechanism of the European Court of Justice of the European Union, the real seat doctrine is almost done, is almost not applied in its strict form anymore within the European Union for EU companies. Very interesting in the light of the Brexit, where many legal forms of the UK might in the future not benefit of the case law that was based or developed around the real seat doctrine. And then all kinds of British companies might face the real seat doctrine in 2019. And this is obviously one of the debates now in the negotiations of the Brexit, whether they can continue to benefit of this. These are two legal approaches to the existence of the legal person within a jurisdiction. On top of this, there is a very important thing to remember in the debate of, for instance, the Netherlands or Ireland or the Bahamas as a country of preference for headquarters. If you want to benefit from certain tax regimes, then a international corporation needs to establish the local version of the legal person, BV, NV. Otherwise, you potentially not benefit from the tax arrangements and tax treaties. Because recognition of a foreign corporation in the Netherlands does not mean that you are a Dutch enterprise. You continue to be an English or Bahama or Maltese or Cyprus corporation. And that is why Apple and U2 and the Rolling Stones and Starbucks and so forth have Dutch legal persons in Amsterdam to benefit from these international tax arrangements. Don't confuse the presence of Dutch legal persons with the name Apple and Siemens and Hyundai and U2 and Beatles and Rolling Stones with the real seat doctrine. That is a voluntary arrangement of those international multinational corporations to establish a Dutch legal person, NVDV, for those purposes. Not because the Dutch law requires it. So 3 different things: real seat doctrine, incorporation doctrine, to be distinguished, and the voluntary act of an enterprise to move to a country like the Netherlands or Cyprus and establish a local legal person. The concept of legal person again. The key of the concept is that it operates within a economy or society as if it is a natural person, a human being. As in, to own assets and property. To make transactions, purchase, sell, and, for instance, to be a party in a litigation. These principles of the legal person seem open-doorish and simple because we're sort of used to it, but please remember that if you look at the history of law, and not that long ago, for instance in Germany, around this real seat doctrine, that they said in the Überseeing case, no foreign company, you're not allowed to litigate in Germany. And so those are not self-explanatory concepts, and that is why legal rules should make sure that that is allowed, that you are allowed to own property and that you're allowed to litigate, else it's useless to have a legal person if you're not able to enforce contracts or enforce your property, etc. Then, if you embrace the whole idea of existence of a legal person, then the subsequent questions are of a life cycle nature, as in, how do I establish it? We will discuss in detail in week 5. And how do we liquidate it? How can it be coming in existence and how does it go away? Then, the legal rule. So if a jurisdiction has a rule like this, for instance, in a sort of restatement of the law attempt to combine Chinese rules, Article 3, or in the UK case law with a beautiful name, Salomon versus Salomon, or in the Netherlands, Article 5 of Book 2 of the Civil Code, or in Germany, the Aktiengesellschaft Gesetz, or the corporate law statute, or in the United States, oh that's the wrong year, it's 1816, sorry for that, the trustees of the Dartmouth College versus Warwick case, where the US Supreme Court develops in a beautiful way the rule in that jurisdiction. And which rule? For instance, a person, both a natural person and a legal person, may perform juristic acts, may transact contracts, property ownership, own property and is able to enjoy all rights recognized by law, being at the same time responsible to honor all contractual and non-contractual liability. So if you have rights as if you're a human being, then obviously you have the similar obligations as honoring your liability. So in 7 lines, you can summarize the whole concept of limited liability. Well, and then we have examples, and your paper is basically an attempt to invite you to look at one example more. Specifically, here we have a certificate of incorporation of a private limited company in the UK. And so if you perform all the establishing steps, you end up in the UK and all the similar jurisdictions, India, Bangladesh, Pakistan, Australia, US, you end up with a A4 that states you exist, dot, stamp, signature. And so that is why in the narrative legal persons are quite often compared to, well, it's just a piece of paper. So the legal person as such is a legal fiction, and a fiction which you can print on a piece of paper and you can put on your wall. That is a legal person. Nothing more. Or in Delaware, this is the certificate of the state of Delaware in the United States of America, with certificate of incorporation, with already the articles of incorporation. Quick and dirty, easy listening, fits on one A4. And who is then putting the stamp? That is someone from the public realm, a government official. So the reasoning is, we create in law the opportunity to have a legal person. We have some nitty-gritty rules how you get one. And then when you get one, when you get this 1A4, then the same authority that creates the legal rule has then the power and authority to sign off on this existence. And that is how I like to share that with you and to demystify law and the mechanisms in it. Other jurisdictions have, like Unilever, more elaborate articles of incorporation. They are put on blackboard, and for the purpose of the paper, last but not least, on the topic of legal person, and then we will have a little break, is that each brand of, in this case, non-food and food consumer products, with Unilever here, Procter & Gamble, Nestle, with all kinds of Axe and Knorr, and what have we? Coca-Cola, Pepsi, Dr. Utker, well, your supermarket. Each brand is quite often a legal person. So the complicating factor in the topic, because so far it was a no-brainer, is that a company you will analyze consists of around 200 legal persons. And then you need to mobilize a little bit more brain power to continue to distinguish between those features of the legal person.
Which one will they look at then?
Sorry?
Which one will they look at eventually?
Well, that is the key question, because from a legal person perspective, each legal person is a legal person. So there is not a concept on the globe of half a legal person, or if you are part of a bigger group that you are not treated as a legal person. So each of those 200 legal persons of Unilever needs to have investor ownership, delegated management, and so forth. From the M&A perspective, if you want to purchase Monsanto with 360 legal persons in its tree, and then you want all of them. That means that when it comes to the A4, you need to acquire ownership of all of them. Meaning that lawyers need to make sure whether the tree is pure and functioning in terms of ownership and ownership and ownership. From a tax perspective, a magical thing happens. That is called consolidated financial statements. And that is the third task of your paper, because the reality of the subsidiaries is that no one cares about the legal persons, that on top of this legal person tree, there's one organizational structure with one CEO and a board and vice presidents, human resources, president manufacturing, procurement, marketing, all the stuff you learned in your course. And then this organizational perspective is having a functional economic purpose. And whoever is having legal persons functions as being a board of Dr. Utker Pizzas in the register of Germany and the Netherlands and so forth, then you have to listen to two bosses. One, your legal person relationships, think of liability, we will discuss next week, and to the organizational hierarchy with, I always take the marketing leg of a organization, because there the instruction is please use red colors on your packaging, or blue. And so the instruction, all the pizzas should be purple in 2018, is an organizational thing. And your analysis of your companies is to distinguish between the both and to describe what is the consequence of the one and what is the consequence of the other. Let's have a break. 11 minutes. See you then.